Hi, Lee Phillips here. I want to talk to you about the common pitfalls that I see when people set up a living revocable trust. What are the problems? Trusts are supposed to solve all the problems, right? Well, actually, they, in a way, create problems because the trust requires some work on your part. You can't just sign the piece of paper, stick it in the filing cabinet drawer. That's what your attorney wants you to do. You pay him the big bucks for setting up the trust, you put it in the drawer, you forget about it. It doesn't solve one problem when you die. Doesn't avoid probate, doesn't do anything else. You're screwed. But the family goes back to the lawyer and they make more money. So, the 999-pound gorilla in the room is the trust has to be funded. That means it has to own anything that you sign your name for. If I have to sign my name to sell it, to get into the bank account, or do whatever it is, then I had better have that asset owned by my trust. Because when I'm dead, I can't sign my name. And that means we have to get the court's permission for somebody else to sign your name, and that's called probate. So you have to fund the trust, bank accounts, safe deposit boxes, water shares, the brokerage account, and it goes on and on. The automobile, we can kind of cheat on an automobile, but put the next auto in the name of the trust. Buy it in the name of the trust. So you're going to have to move all of these assets. You physically got to go to the bank, make out a new signature card, and the bank's going to want a copy of the trust. They're going to want a copy of the certification of trust or the summary of the trust. The banks want all this crap. And to be honest with you, there is no rule on it. It depends upon what the banker ate for lunch. That's about what it boils down to, boys. So you do whatever the bank wants. You do not need a new EIN number, though. No. It's your Social Security number by law. And the bank may not understand that. So, it's going to require work on your part. It's got to be funded. The problem is, you're going to procrastinate all this crap. And that's another major pitfall. You have to cross the T's. You have to dot the I's in order to make the trust work for you. And you can't procrastinate it. I had a call this week. Everything's set up at the lawyer's office. We hadn't signed the trust yet, and the husband died. So don't procrastinate it. You're going to be in some life situations where you have to change the trust. You get divorced. I get remarried. The old wife's name's on the trust. Now, in a lot of states, the trust becomes inactive or it isn't honored anymore after divorce, but I've seen lots of situations where the ex was the one that was named on the trust, or the ex was named on the bank account. No, the bank account needs to be in the name of the trust, not you and your husband's wife's name joint tenants. So you have to do all of this stuff, and if something like the divorce changes substantially, then you may have to change your trust. You may have to go back in. And when you change a trust, when you amend your trust, and trust can be amended, it's easy. But when you amend the trust, you need to go back to the bank and say, hey, look, bank, amended trust, you're going to honor this trust, this amended version, not the first version. So that you basically have to start over in moving all of these assets. You've got to make out a new deed to your piece of property. Now, you shouldn't be triggering taxes and you shouldn't be triggering transfer taxes and all of that garbage when you make out the deed to the living revocable trust. But it's a hassle. You got to go back and you got to redo all of this stuff when you actually amend or change the trust. Now, don't lose a copy of the trust. That's a big deal, guys. If I say that my bank account is governed by the terms of this trust, I'd better well have a trust. If you lose the trust, you're screwed. Let me just tell you that. You have to go back to court and you have to ask the judge to approve this new trust, so you don't lose the copy of the trust. Now, in the old days, we had a trust, and I kept a copy in my files, originally signed copy, and I gave a copy to the client. And I don't know how many clients have lost their copy, and I've had to give them my copy. Well, today, every state, we can use a scanned copy of the trust. So go in and make sure your old trust is scanned into your computer files. That's as good as an original in most situations. Now there again, the bank may or may not accept it because it depends on what the banker ate for lunch. So don't lose a copy of your trust. Pitfalls? Yeah, there are some. Your trust requires work. It requires care and feeding. And you've got to put that into your sequence, and you've got to get it done. You can't procrastinate it. And you have to remember that you are acting as a trustee. I have my trustee hat on now. I don't have my personal hat or my joint tenant hat with my husband and wife. I have my trustee hat. So I am managing these assets that are held by the trust. They need to be owned by the trust. I'm managing them as trustee for my benefit as the beneficiary. Lee Phillips, now get my How to Use a Trust ebook, and in fact, I've got a new webinar out. It's good. Watch it. We talk about trusts and stuff, and pick up those. They're free, no problem. Just click below, and in fact, love us and like us and all of that sort of stuff, so that we can reach more people. I think we're giving good content. So Lee Phillips talking about pitfalls in having a living revocable trust.